Hello, hello. Hi, Cindy and Mark and Pete. How is everyone? It's been a while, huh? I'm here. Hope everyone's doing well. It's been a while. Forgot what I was doing here. Let's see if we can't figure this out. Together again. All right. Everybody ready for Halloween? 10 more days. Go. All right. So, we're going to talk about the Daybell case. That's one case that I tried to follow from the beginning, and I kind of been slacking and not keeping up with all the updates. And boys, there have been a lot. Quite a few things have happened, and I'm going to try to cover them. There's been a lot, so let's see. For those of you who don't know, Lori and Chad Daybell. It was Lori Vallow and Chad Daybell. They pled not guilty to multiple counts of first-degree murder and conspiracy to commit murder for the deaths of their 7-year-old son Joshua, which he goes by JJ, or went by JJ, and 16-year-old Tylee Ryan, two of Lori's kids, along with Chad's previous wife Tammy. The Daybells' joint trial was scheduled to begin in January. There was a bunch of motions and things in the past year or so where they tried to sever the trial. In other words, have two different trials, and that was denied. So they were supposed to have one joint trial. And then there was a motion to move it to a different county, which they approved that one. They were supposed to be going to Ada County instead of staying in Fremont. What else? Lori was deemed incompetent, so she was in the mental ward, and yada yada. A whole bunch of stuff happened. But most recently, on September the 15th, motions were filed to ban cameras from any future hearings. Claire, there she is. Motions were filed to ban any cameras from any future hearings. Got sidetracked, sorry. Nothing unusual. Jim Archibald and John Thomas, who were Daybell's attorneys, and in a lot of this they refer to Daybell as Lori Vallow because, I mean, they are married. But I don't call her Daybell, I call her Vallow. But in this case, they're referring to Lori. They filed a motion to ban cameras from any future hearings. They're saying that the media abused their privilege to photograph and video proceedings. The prosecuting attorneys, Lindsay Blake and Rob Wood, filed a response to the motion supporting the idea of a camera ban. Archibald argued that by allowing cameras in the courtroom, his client will have to prove her innocence instead of the state having to prove her guilt. I don't understand what the cameras have to do that with that. They were talking about, hey, Mr. Earls, the fact that the cameras were like fastened at their tables and microphones, and you know, all the cameras were focused on her instead of who was talking. And you know, of course they want to see her reactions to what's being said, you know, things like that. The defense and the prosecution noted that while they believe in the constitutional right to freedom of press, they don't believe it includes broadcast. Both sides stated the incessant media exposure is impeding on Lori Daybell's right to a fair trial. I don't agree with that either, but, you know, I guess they're talking about all the media coverage that she's had and whatever, that they're painting her in a bad light. I mean, she painted herself in a bad light when she done the crime. So, Steve Wright, who is an attorney for the East Idaho News and a lot of other media stations, he was the one representing all of them. He argued that news organizations followed a court order during the last hearing and did not take any unauthorized steps while recording and broadcasting. It is regrettable that counsel feels misled that they didn't notice the microphones, but they were approved first and foremost, along with the cameras. So that's what they're referring to, is the microphones that were on the desks in front of them. So when Lori was whispering to her attorneys, I guess it was picking it up. But anyway, hang on one second. All right, where was I? There's a significant difference in telling the court that the courtroom should be open, but only to people who physically want to come and sit in the courtroom, because if it's broadcast to other people, her rights are now jeopardized. Exactly, Mr. Earls. Okay. Boyce interrupted Wright to disagree, saying at some point, if there is so much saturation that it presents a presumption of guilt, I think that's entirely possible in this case. And I'll tell you, I'm quite concerned about that. So in other words, the judge agreed that the cameras and the microphones and everything in the courtroom was just creating doubt for the jury, or could create doubt for the jury, which I don't understand why it would in this case and not every other case that's being heard, you know? All right, Boyce also noted, Boyce is the judge. Boyce also noted that he does not know the members of the media, who they're employed by, or who pays them, so he cannot personally guarantee that they will always follow the rules. Although there have been no circumstances thus far where media has not followed any courtroom protocol in this case. So, what about these lawsuits that would come from the media about the politics? Right to know, I don't even know if that, yeah, that's what the whole argument was about. Wright said the pretrial publicity was not going away, and the motion was an inappropriately extreme response to actions that were approved by the court. I agree. I agree totally. It was already approved, the cameras and the microphones, and they didn't place them in places that the courts already didn't approve for them to be, so I don't understand any of that. Boyce ended his conversation with Wright by stating, "I'm very concerned that this is going beyond access, that this goes to creating a financial enterprise that revolves around the case." That's with any high-profile case. Any high-profile case, there's a financial enterprise involved in it. The judge did not immediately make a ruling and said a written decision will be forthcoming. The grandparents afterwards talked to the media, and they said, "To me, the issue is not the cameras or the audio. The issue is Lori playing to the camera. Absolutely, cameras should remain. I want my family and our friends and the people that follow us worldwide. They deserve to know what's going on." So, In addition to the motion to ban cameras, two other motions were discussed. One which would allow Lori Vallow and Daybell to appear in court in street clothes. Really? That there has to be a motion for this? That's a waste of time to file motions like that. Although she has appeared in street clothes in previous hearings, according to her attorneys, it was never in writing. Her attorneys argued that having her appear in street clothes helps with her right to a fair trial. The prosecution had no opposition, and Boyce granted the motion, so Lori can wear street clothes now. Ay, ay, ay. Some of the things that these attorneys come up with baffle me. Hang on one second. Let me get a drink. I gotta have my coffee. All right. Did I tell what the date of that was? I don't even remember. Mine's all over the place tonight. September the 15th. Yeah, I think I did. All right. So, moving on to September 23rd. District Judge Stephen Boyce issued an order banning video and still cameras from all upcoming hearings. So, in other words, the motion hearing we just talked about was approved by the judge. He banned all cameras and stuff from the courts, from future hearings. He wrote in his order that he didn't find any misconduct or interruptions from the media during previous hearings and said journalists in the courtroom have been professional and respectful. But the judge is worried about pre-trial publicity and noted visual coverage of the case could impede the ability to pick a fair jury. Although Boyce revoked video and photographic coverage, he wrote that audio proceedings will continue to be permitted using in-court microphones. It's unclear if a live audio feed for public dissemination will be allowed. So they can record by microphones, but they can't do a video recording, and they don't know if it's going to be broadcast live like all the other hearings have been, which is going to suck because this is going to be a good case, and I had planned on covering it, but don't look like we might get a chance to do that now. All right, moving on. On September the 27th, lengthy motions were filed by John Pryor, who is Chad Daybell's attorney. He argued his client's trial should be continued due to a substantial amount of investigation and preparation, along with a significant amount of evidence he says he has not received from the prosecutors. There's no possible way to complete the investigation and be prepared for a death penalty trial in January of 2023, which is when the case was supposed to be. Death penalty cases are unique in the criminal legal system and require counsel to undertake an extensive, time-consuming investigation. He argues that because this is a capital murder case, he must prepare for essentially two trials, the merit phase, and should there be a conviction, the sentencing phase. The attorney noted his time has been focused on complex merit phase, and he is just now starting the initial stages of the sentencing phase. So, because he's behind, it's everyone's fault and Chad shouldn't go to trial? Whatever. Chad is asking for his trial to begin no earlier than October of 2023. That's another year from now. Another motion, which was filed last year, I believe, was the motion to sever the two cases, which was denied. Now, that motion can be refiled as many times as they want, and they did. They refiled it again. In a motion to sever, John Pryor argued that having Chad Daybell tried with Lori Daybell would deprive his client of his constitutional right to present a complete defense. As much as I would like to have these two tried together, at this point, I think it might be best just to sever the trials. Lori keeps doing all of this incompetency stuff, and so that's just dragging it on for Chad's trial because they're being held together. But then again, I don't know. If one's found not guilty, the other might be found not guilty, which I don't think either one of them will be found not guilty. There's too much evidence against them. So that's kind of up in the air. We'll see. Where else? Pryor said he had plans to introduce prior bad acts of both Miss Vallow and Alex Cox, who was Lori's deceased brother, as well as evidence regarding the relationship and the death of Mr. Cox. Pryor also noted that Chad is requesting a continuance in the trial start date, but Lori has not waived her right to a speedy trial, and because of that, the cases should be separated. And because of that, I think they might win that one, because Lori did not waive her right to a speedy trial, which means her pretrial hearing has to be within 6 months. But she keeps postponing due to the incompetency thing, so I don't know how that works with the speedy trial thing. All right. Chad wants cameras in the courtroom during his trial, and he wants the proceedings live streamed for the public. In another motion filed, Daybell's attorney is asking Judge Boyce to reconsider the ban. The defense has concerns that the lack of public access to the trial would cause financial hardship to members of the families, limit the parties' families' access, and limit the public from adequate access to what is a trial of great interest to the public. This request came just a week after Boyce issued the order prohibiting the cameras. All right, Chad and Lori's death penalty cases are currently joined, and the trial was scheduled to begin January the 9th. Who knows if that's going to happen now? Well, we know it's not going to happen, and we'll get to that in a second. Let me check the chat here real quick. Okay, nothing going on there. On October the 3rd, Lori's defense team is asking the judge to pause court proceedings in her case and postpone her trial. Imagine that. Jim Archibald and John Thomas, who are Daybell's defense attorneys, Daybell meaning Vallow Daybell, requested Judge Stephen Boyce continue the trial and toll the time limits in the case. Tolling time limits essentially pauses deadlines required by the court to file certain motions. In other words, and everything just gets suspended and just put out in air, like it's up in air. No deadlines are being counted, no times being counted, nothing. It's told, it's stopped. Then on October the 6th, the judge agreed, and he ordered that all matters with Lori be suspended until her mental competency can be determined. He responded to the motion from Daybell's attorney asking for court proceedings to be paused. Prosecutors submitted a response under seal Wednesday, and a closed hearing was held that afternoon on shortened time to discuss the motion. Due to legal issues raised by counsel in their motions and during the hearing, this case is hereby suspended until a determination of Mrs. Daybell's competency to stand trial can be determined. As a result of a need to determine Mrs. Daybell's competency, the court sees no alternative at this time than to vacate the January 9th trial. Now, as far as all of Chad's motions, there was going to be a motion hearing on October the 13th where Chad was going to be there. Lori was supposed to be there as well, but because of all of that, she no longer was going to be at the October 13th hearing. Pryor wants Chad's case severed from his wife's and is asking the judge to postpone the trial until late 2023. It's unclear how the pause in Lori's case affects Chad's, which is what I'm wondering. And are they just going to keep him? I mean, I really don't care if they do or not. He deserves it, but is he just going to stay behind bars and just wait until she's competent enough for both of them to be tried? I mean, what's going on with that? In other motions filed, prosecuting attorneys Lindsay Blake and Rob Wood opposed the request from Pryor to allow Chad to wear street clothes to the hearings. Prosecutors raised no objection to Lori wearing street clothes during the hearing last month, but at the time, cameras were allowed in the court. So now that cameras aren't allowed, he don't see no point in them wearing street clothes. I guess their thing is they want to look good for the jury, but yeah, they don't want them to look good. What else? Let's see. The prosecutors also objected to Pryor's motion to allow cameras in Chad's trial, stating that Boyce has already ruled and reopening the argument is a waste of court time and resources. At the motions hearing on October the 13th, dressed in a white shirt, blue tie, and khaki pants, Chad Daybell showed little emotion during the 2-hour hearing. Several motions were on the agenda, including whether to pause Chad's case, separate it from Lori's, and whether the trial should be rescheduled. John Pryor, Chad Daybell's attorney, argued his motion to delay the start of his client's trial until at least October 2023. One trial for both Chad and Lori is currently scheduled to begin in January, although all matters in Lori's case were suspended last week until her mental competency can be determined. Pryor said he would be ready for a trial in January, but would prefer more time to prepare. Given the large amount of evidence, he also says he has not received everything he needs from the prosecutors. Fremont County Chief Deputy Prosecutor Tanya Rawlings responded that her office has turned over all evidence they currently have, but acknowledged some DNA and other potential items could be provided at a later date. The current deadline for the prosecutors to turn over all evidence to Pryor is November the 22nd. So they still have another month. So I don't know what Pryor's complaining about. The prosecutors did not object to the continuance as long as the trial remained with Lori's. If it was delayed, Rawlings asked it to begin September 2023. So it spans over 2 fiscal years. That would help Madison and Fremont counties handle the financial impact of an expected 10-week trial. Rawlings asked Boyce to consider granting a stay or pausing Daybell's case until Lori's status is determined. Pryor adamantly opposed the idea. Miss Vallow, is allegedly mentally unfit, and the court is going to put a stay on me because potentially she has a problem. I object on that basis, Pryor said. He did not like that. Boyce denied the motion for a stay, but voiced concerns he has with postponing the trial given potential scheduling conflicts in Ada County and the fact that Daybell has been in jail for over a year. So, he's going to be in jail for the rest of his life. What's a year? There was some motion also filed called the motion for bill of particulars, which I don't really know what that was. I did know it. Never mind. It's like told you this. It's been a while. I'm out of practice here. The motion for bill of particulars was denied. A bill of particulars informs a defendant of the nature of their charges and the evidence against him or her. Lori's attorneys also filed a motion for a bill of particulars in her case. The prosecutors objected to the motion, arguing that the indictment lays out why Daybell is being charged, which that makes sense. I mean, why do you need a bill of particulars when you're already told in the indictment why you're being charged? I don't know. Boyce denied the motion on the grounds that there is no basis to have a bill of particulars prepared, which he's right on that one. Pryor's motion to sever Daybell's trial from Lori's was also on the agenda, but discussion on that matter was postponed until November the 10th to give him time to review the prosecutor's response, which was filed Wednesday the 12th, which was the night before this. An author writing a book about the case also argued a motion she filed asking for Boyce to unseal court documents and transcripts of previous hearings that were closed to the public. Boyce said he will take the request under advisement. So, their next court hearing is going to be November the 10th, and it's just going to be for the motion to sever again, which keep your fingers crossed that they don't do it, because I'd like to see them both tried together. I don't care how long Chad has to sit and wait before Lori decides, or they decide Lori's competent, which I was saying right the first time. I think she's playing the system. She's just pretending to be incompetent so that she doesn't have to go to trial. I don't believe for 1 minute that she's not fit to stand trial. So, in closing, Larry Woodcock, which is JJ's grandfather, after the hearing, he spoke with the media. He said, even though it appears the trial may be delayed, his family is prepared. And I quote, "Whatever this turns out to be time-wise, we'll be there. We've waited 3 years, and if it's January 17th, that's fine. If it's July 17th, that's fine. We're going to be here. We intend to follow this through if good Lord is willing." So, another thing that I wanted to mention is they still haven't released the bodies of JJ and Tylee. They're still at the morgue, I assume, in a freezer or a vault someplace. So the family still hasn't had closure. They haven't been able to say their goodbyes and have a service. And it's been 3 years. So I don't know what they're waiting on. The autopsies have already been performed. All the evidence has been taken. Pictures, whatever they need has all been gathered. Why can't the family bury those 2 kids? Why do they have to keep them? I don't get that. It's been 3 years. Let these people have closure and have a viewing and a service for these 2. So that I'm sure is going to be coming up in a motion hearing or somewhere at some point. But that's the updates that I have on this. Is there any questions or comments? I mean, nobody's been talking. He spelled your name right finally. Let's see. All right. Well, if nobody has anything, I'm not gonna open the panel because I just wanted to come on real quick and give these updates and share that with everyone. And that's it. So I appreciate people who came and showed support. Make sure you give it a thumbs up and subscribe if you haven't, and we will talk next time.